going on, but I'm going to remind you and request that this is still a court of law. I'm expecting extreme calmness, order, as the court procession goes on, and silence. Those that have their phones on, kindly have them in silent mode or switched off. I do not expect any distractions. This matter. Sir?
Ancora, Bambi afande oba mukozi. Olina byonkola.
Quite full and there's all this media going on, but I'm going to remind you and request that this is still a court of law. I'm expecting extreme calmness, order, as the court procession goes on, and silence. Those that have their phones on, kindly have them in silent mode or switched off. I do not expect any distractions.
Ronald Rwanda and Bayan Tulinawe. Bayan Tulinawe and Pura.
Hello, microphone 1 2. Hello, audio testing. Hello, microphone. Hello, audio. Hello, audio. Audio 1 2. Hello. Hello, microphone. Hello, audio testing 1 2. Hello. Hello, hello, hello.
Worship, we have an application to make before any other step is taken. And this now takes precedence over any other matter.
Sorry, Council.
I was saying, Your Worship, we have an application to make before any further step is taken in these proceedings, which, in our opinion, we consider to be fundamental and takes precedence over any other matter if we are permitted, Your Worship, to proceed with the same before they can even talk of producing any other details. So glad to Your Worship. Your Worship, is an application brought under Section 5 of the Human Rights Enforcement Act, Cap 12. And it's about enforcement of rights and freedoms by magistrates' courts. First, to address your jurisdiction and then the proceeding. On the question of jurisdiction, Your Worship, it is subsection 1 of section 5, which provides that a magistrate's court, subsection 1 of section 5, which provides that a magistrate's court shall hear and determine an application relating to the enforcement and violation of human rights and freedoms guaranteed in Chapter 4 of the Constitution in any of the circumstances not referred to in section 4, subsection 1. Because those ones are for the High Court, Your Worship. That is the jurisdiction vested in this Honorable Court. And the procedure, Your Worship, is also provided for, or rather stipulated, under subsection 2. That the application under subsection 1 may be made in any language, orally, in any language, orally, or in writing, or in any other form, as may be prescribed by regulations. So there is a wide latitude on the procedure, Your Worship, and we are seeking to make it orally before you. And finally, on the procedure, subsection 2 of section 7, subsection 2 of section 7 provides that where a human rights matter arises in any proceedings before a magistrate's court, the court shall immediately stay the proceedings in the main matter and first determine the human rights issues raised. Where a human rights matter arises in any proceedings before a magistrate's court, the court shall immediately stay the proceedings in the main matter and first determine the human rights issue raised. That particular provision, Your Worship, is couched in mandatory terms, and we seek your indulgence, Your Worship, that we first deal with the human rights issue in accordance with the law. And the human rights issues we are raising, Your Worship, are as follows. Number 1, Your Worship, deprivation of liberty of A1 Dr. KIZZA Besigye without any lawful justification, contrary to the provisions of Article 23 of the Constitution. Article 23, Subarticle 1 provides that no person shall be deprived of personal liberty except in any of the following cases. A, in execution of a sentence or order of court, and so on and so forth. So in this particular case, Your Worship, facts speak for themselves that Dr. Besigye is in the custody of the prisons authorities who are guarding him here. Yet this honorable court granted him bail. It's on record. Court granted him bail. To Your Worship, he has no any pending charges whatsoever under any court of law in Uganda. It's not there. For the record, Your Worship, previously there were charges that had been preferred against him before the defunct General Court Martial in Machindya, which charges were terminated, rather the charges and the proceedings were terminated by the Supreme Court in its landmark decision, Your Worship, of 31st January, which I'm sure court has taken judicial notice of. And the state is aware of this. Your Worship, it's straight law that one cannot be on remand without a valid remand warrant, without a court order. It's straight law. No person can be on remand without a valid court order or remand warrant. We challenge the state and the prisons authorities to produce any valid remand warrant. Your Worship, which is also the other right, which is also guaranteed under the Constitution, Article 23, Subarticle 3, which provides that a person arrested, restricted, or detained shall be informed immediately in a language that the person understands of the reasons for the arrest, restriction, or detention, and of his or her right to a lawyer, and so on and so forth. This provision is quite instructive, that a person whose liberty is curtailed, who is restricted, who is detained, shall be informed of the reason as to why he is in custody or is in detention. Your Worship, Dr. Besigye up to now is not aware of any justifiable reason under the laws of this country as to why his liberty is being curtailed. That is Article 23, Subarticle 3. The other right, which has also been, that where a person is restricted or detained, the next of kin of that person shall, at the request of that person, be informed as soon as practicable of the restriction or detention. 2, the next of kin, lawyer and personal doctor of that person shall be allowed reasonable access to that person. The full import of this provision is that a person restrained or detained has a right to access his personal doctor. Your Worship, your applicant here, the accused person, Dr. KIZZA Besigye, is sick. Last time he appeared, last time this court sat on Tuesday, he even wrote a cheat that he is indisposed. He could not make it. My colleagues and I visited him on Wednesday in Ruzira, and indeed confirmed that he is sick. And the prisons authorities can also confirm that he is sick. But to date, he has not been at all permitted to have his personal physician examine him or offer him any medical support needed. This is a gross violation of Article 23, sub-Article 5, and also the next of kin. The next of kin should know the reason why their loved ones are restricted, or rather restrained or detained. Your Worship, the spouse of the applicant, that is the Honorable Winnie Byanyima, who is in the country, has not been furnished any reason as to why her husband is in Ruzira. On a light note, Your Worship, and to substantiate this matter, today is a Valentine's Day. It's a day for loved ones to share pleasantries. It may sound light, but it's a very serious one. Dr. Besigye should also be with his loved ones today. Not only his wife, but all his relatives. He's a family man. It's a day of families to reunite, to show affection to one another.
Monday, his sister was denied access.
And on Monday this week,
Stella.
this week, his sister, Stella, who had gone to take supplies to him, food items, was denied access to him. Finally, on the rights which have been violated, under Article 24, Article 24, Your Worship, provides for the right to respect for human dignity and protection from inhuman treatment. Respect for human dignity and protection from inhuman treatment. The kind of cruel and inhuman treatment Dr. Besigye is subjected to is horrendous, is reprehensible, is preposterous. Your Worship, to be in custody of the prison's authorities without a valid remand warrant, without a court order, is such an egregious abuse of one's right, which court cannot sanction or approve. We may be even on record, Your Worship, even writing a small cheat to his loved ones or the lawyers, whatever. It's a tug of war. Just a small cheat. Even when we visit him, the environment is not conducive at all for a lawyer-client interaction or interface. Literally, the prisons authorities participate in the conversation, the discussion. There is no confidentiality. You are seated, you are given a room there, they bring the prisons authorities, they are there, listening to you as you are laying strategies on how to defend your client. What are the available remedies, Your Worship? In subsection 2 of section 7, we reiterate that particular prayer. Subsection 2 of section 7. Yes. The first remedy is to stay the proceedings and dispose of the human rights issues. That's what subsection 2 provides, that this court stays the proceedings. It's our prayer that you stay the proceedings and first dispose of the human rights issues or violations that we have raised here. In subsection 9, and rather in section 9, orders that may be made by court in human rights cases. Subsection 1 of section 9, where the competent court determines that a fundamental right of freedom has been violated, unlawfully denied, or should be enforced, the competent court shall issue orders it considers appropriate, including an order for compensation. We may not ask for compensation, Your Worship. Your Worship, we pray that you be pleased to invoke the powers of this honorable court under subsection 1 of section 9 to issue appropriate orders, because it gives you the discretionary powers here, Your Worship, that the court may grant orders it considers appropriate. And in our opinion, the most appropriate order this honorable court can give is immediate release of Dr. Besigye from unlawful custody. Immediate release. That is the most appropriate now. The other order, Your Worship, in subsection 2, paragraph C, subsection 2 of section 9, orders which shall include measures aimed at cessation of the continuing violation of human rights and freedoms. To order immediate cessation of violations. And here, Your Worship, if you may add on another prayer. Okay. It's under that provision that, Your Worship, that this court is clothed with the powers to order for the release, immediate cessation. You are clothed with jurisdiction to order for the immediate release of Dr. KIZZA Besigye. The other prayer, Your Worship, we are making for regards to violations under Article 22, the last one now, Your Worship, under Article 22, protection of right to life. No person shall be deprived of life intentionally, except in execution of a sentence passed in a fair trial by a court of competent jurisdiction in respect of criminal proceedings under the laws of Uganda. They are threats to the life of the accused person, Your Worship. Threats to life. The circumstances under which he is being detained pose a serious threat to his life. The horrible treatment he is subjected to. But even a statement issued by the army, the CDF himself is on record issuing threats that Dr. Besigye shall only leave Luzira in a coffin. He's on record saying that. That is General Muhoozi Kainerugaba. That Besigye shall only leave Luzira in a coffin. That's a very serious one, Your Worship. So this court is enjoined to protect the life of the accused and all his other rights. Of course, the other threats that will be subjected to firing squad in June and whatnot, but we wanted to single out the one relating to his imprisonment now, that will only leave Luzira in a coffin. So we pray that, Your Worship, and the other prayer, the last one we are making, the prayer, Your Worship, is in subsection 2 of section 9. That is paragraph 5 and 6. That the court can issue criminal and other judicial or administrative sanctions against the persons liable for the violations criminal and other judicial or administrative sanctions against the persons liable for the violations. To start with, these ones. These ones, Your Worship.
And the battalion behind you.
All these security officers in charge of his custody, starting with the Commissioner of Prisons, should be sanctioned. Mr. Byabashaija Johnson should be sanctioned. Your Worship, the Director of Public Prosecution is equally liable in this, together with the Attorney General. They are equally liable in this. They should be subjected to criminal sanctions for violating Dr. KIZZA Besigye's rights. We do so pray.
Non-repetition.
We do so pray, Your Worship. Okay. It's under that provision that, Your Worship, that this court is clothed with the powers to order for the release, immediate cessation. You are clothed with jurisdiction to order for the immediate release of Dr. KIZZA Besigye. The other prayer, Your Worship, we are making for the regards to violations under Article 22, the last one now, Your Worship, under Article 22, protection of right to life. No person shall be deprived of life intentionally, except in execution of a sentence passed in a fair trial by a court of competent jurisdiction in respect of criminal proceedings under the laws of Uganda. They are threats to the life of the accused person, Your Worship. Threats to life. The circumstances under which he is being detained pose a serious threat to his life. The horrible treatment he is subjected to. But even a statement issued by the army, the CDF himself is on record issuing threats that Dr. Besigye shall only leave Luzira in a coffin. He's on record saying that. That is General Muhoozi Kainerugaba. That Besigye shall only leave Luzira in a coffin. That's a very serious one, Your Worship. So this court is enjoined to protect the life of the accused and all his other rights. Of course, the other threats that he will be subjected to firing squad in June and whatnot, but we wanted to single out the one relating to his imprisonment now, that he will only leave Ruzira in a coffin. So we pray that, Your Worship, and the other prayer, the last one we are making, the prayer, Your Worship, is in subsection 2 of section 9. That is paragraph 5 and 6. That court can issue criminal and other judicial or administrative sanctions against the persons liable for the violations criminal and other judicial or administrative sanctions against the persons liable for the violations. To start with, these ones. These ones, Your Worship.
And the battalion behind you.
All these security officers in charge of his custody, starting with the Commissioner of Prisons, should be sanctioned. Mr. Byabashaija Johnson should be sanctioned. Your Worship, the Director of Public Prosecution is equally liable in this, together with the Attorney General. They are equally liable in this. They should be subjected to criminal sanctions for violating Dr. KIZZA Besigye's rights. We do so pray.
Non-repetition.
We do so pray, Your Worship. Thank you. Your Worship, if I may be permitted, with the leave, Your Worship, I'd left out one prayer in 6 because I had highlighted it, Your Worship, to guarantee non-repetition, that court, amongst the orders that can be issued, guarantees of non-repetitions. So court is again enjoined to make some safety measures and provide mechanisms to ensure that there is no repetition of violations. In other words, they should not be allowed. They are not. You know, the sections referred to by my land colleague refers to where in any proceedings. That means the violations mentioned here, the violations should arise from the proceedings before a given court. You know, the violations suggested by my land colleague should have arisen from these proceedings, which is not the fact. An accused person cannot be in court, faces other violations, then he uses them to stay proceedings in a totally different trial. That is a fallacy. So this honorable court cannot stay these proceedings or make any orders.
unless my land colleague had brought a separate application. Because the remand of A1, his incarceration in Ozira, has no connection with this case in court. Therefore, applications cannot arise from this case and prayers made for his immediate release when in this matter is already on bail. It is clear that from the proceedings before this court, there is no human rights violation against A1. Not at all. He is on bail. That should be very clear. Therefore, the submissions by my land colleague that this court should issue orders for his release are untenable, have no backing. And all case law under the Human Rights Enforcement Act, where parties have been successful, the violations have been arising from the given cases. Either they allege torture from police, but that torture should be as a consequence of their incarceration. It cannot be done at a different case where you're on bail and you meet a person on the road, they stone you, then you come and say your rights have been violated. So this case should stay. It's unheard of, So therefore, my land colleague should have filed an application, a totally different application for his incarceration has no bearing on this case. Two, will still move on to the fact that his incarceration is unlawful and he was released from. They are not. The sections referred to by my land colleague refers to where in any proceedings. That means the violations mentioned the violations should arise from the proceedings before a given court. The violations suggested by my land colleague should have arisen from these proceedings, which is not the fact. An accused person cannot be in court, faces other violations, then he uses them to stay proceedings in a totally different trial. That is a fallacy. So this honorable court cannot stay these proceedings or make any orders. Unless my land colleague had brought a separate application. Because the remand of A1, his incarceration in Ozira, has no connection with this case in court. Therefore, applications cannot arise from this case and prayers made for his immediate release when in this matter is already on bail. it is clear that from the proceedings before this court, there is no human rights violation against A1. Not at all. He is on bail. That should be very clear. Therefore, the submissions by my land colleague that this court should issue orders for his release are untenable, have no backing. And all case law under the Human Rights Enforcement Act, where parties have been successful, the violations have been arising from the given cases. Either they allege torture from police, but that torture should be as a consequence of their incarceration. It cannot be done at a different case where you're on bail and you meet a person on the road, they stone you, then you come and say your rights have been violated. So this case should stay. It's unheard of, So therefore, my land colleague should have filed an application, a totally different application for his incarceration has no bearing on this case. Two, will still move on to the fact that his incarceration is unlawful and he was released from jail by the now defunct court martial. This is not true. The judgment of the Supreme Court was very clear, that the trials would be transferred. The judgment didn't state that the trials are stopped and people should be released. That is a fallacy. There is no such judgment. So, he is in prison legally until the case files are transferred to a civil court. And the Supreme Court gave 14 days. We are still in the 14 days. So, even if court agrees with my land colleague that, okay, the violations that, if any, that are being occurred to him arise from this case, and this court has jurisdiction under this violation, there is not any such violation. So, there is no ruling or judgment by any court that trials of civilians in the general court martial, that people have been tried in the general court martial should be released from prison, and that their incarceration is unlawful. It is not there. So, the questions of he should either seek bail from a court with competent jurisdiction or seek other orders, but not through this court, using this case I would submit that the reason for his incarceration are not the concern of this honorable court. This court should not even look into the issue of his incarceration here. He is on bail. The issue should be handled by those who incarcerate, who remanded him, or if they make any application, which is independent of this case. They cannot mix his incarceration and this case. They are totally different matters. So, I don't want to, due to that, I don't want to go into whether they are violations, whether his rights are being violated. You're not legal. And there is no ruling that he is illegally in prison. You know, you cannot be in prison and celebrate Valentine as my land colleague wants. It won't happen. There are inconveniences of life. Or have total. So, you know, I would sum up that this court has no jurisdiction to make orders arising out of its incarceration. That is in as far as these orders arise from this criminal matter. They should have made a separate application to this honorable court. For his incarceration has no bearing on the case before this court. 2, if I am wrong and indeed this court has the jurisdiction, he is not illegally in custody. He is in a lawful custody. And the Supreme Court judgment is clear, he is in a lawful custody. So, I would pray that the prayers by my land colleague that Attorney General DPP be reprimanded and the prison. No, what they are doing is lawful. So there is no illegality that has been made. So, I would pray that this honorable court dismisses the application. And allows us, we had made the first application, and allows us, this honorable court should allow us to present our last witness today, and we have all these times been chastised by my land colleagues for not presenting witnesses. When we present a witness now, my land colleague doesn't even want to hear about the witness at all. So we pray.
So just give me a minute. Getting an IT malfunction here.
And there is no ruling that is illegally in prison. You cannot be in prison and celebrate Valentine as my land colleague wants. It won't happen. There are inconveniences of life. Or have total. So, I would sum up that this court has no jurisdiction to make orders arising out of its incarceration. That is in as far as these orders arise from this criminal matter. They should have made a separate application to this honorable court. For his incarceration has no bearing on the case before this court. 2, if I am wrong and indeed this court has the jurisdiction, he is not illegally in custody. He is in a lawful custody. And the Supreme Court judgment is clear, he is in a lawful custody. So, I would pray that the prayers by my land colleague that Attorney General DPP be reprimanded and the prison. No, what they are doing is lawful. So there is no illegality that has been made. So Your Honor, I would pray that this honorable court dismisses the application. And Your Honor allows us, Your Honor, we had made the first, and allows us, this honorable court should allow us to present our last witness today, Your Honor. And we have all these times been chastised by violent colleagues for not presenting witnesses. When we present a witness now, my land colleague doesn't even want to hear about the witness at all. So we pray.
So just give me a minute. Getting an IT malfunction here.
Essentially, what the state is saying is that A1 should not be complaining because he is lawfully incarcerated. Your Honor, the Supreme Court judgment did not say that A1 and other persons in his category should remain in custody. So we are at a point where the warrant that remanded him expired. About 2 weeks ago.
3rd February.
The court which issued that warrant was told not to sit again. And this is the first court that he has appeared in for the period for which he has been in illegal detention. Your Worship, my learned friend Mr. Lukwago asked the state to produce the document under which he is incarcerated, or even the prison's officials. The state skirted around that issue because in reality there is none. So he might be in the category of people who used to be called lodgers many years ago. They are in the prison system under no authority of any office, any court order. Your Worship, the state has not even addressed any of the instances that my land friend cited in Article 23. He just ignored them as if they don't exist. So we submit that the unlawfulness of the custody for A1 is clear. And we invite the court to act in the manner provided in Section 9 to grant A1 the necessary remedies. On the question of jurisdiction, it is our submission that the court has the necessary jurisdiction. It is in black and white in the text that my land friend read, Section 7, subsection 2.
And 5, 1.
And 5, 1. And it is not an error that this jurisdiction was given to the courts. The provisions do not speak of any proceedings and then say any violation in those proceedings. And so our interpretation, Your Honor, is that both Section 5 and Section 7 apply in this situation. This first court that the accused has appeared in is the one where he's raising the human rights violations that he has been facing for the last 2 weeks, at least. We therefore, Your Worship, reiterate our prayer that the court exercises the jurisdiction it has to stay these proceedings, order cessation of the continued unlawful detention of A1, to order the authorities to seize any repetition of that unlawful detention, and the other prayers that my land friend made. Your Worship, it would be a travesty for the court, being aware of the violations, to tell those violating to continue, or to tell the one who is complaining that I can't hear you, I have no remedy for you. You go back and continue to suffer. Your Worship, that's what would happen if the court were to find otherwise. So we very humbly pray that the court grants the remedies we are seeking. Certainly, again on a light moment, it would be an amazing gift on a day like today for that type of order to be made. We so pray, Your Worship.
brief additional submissions, Your Worship, on the question of jurisdiction. Strictly on the question of jurisdiction. Your Worship, the nexus between this application for enforcement of rights and the trial before you. I think he dwelt so much on that point to drive a point that actually these are different matters altogether, not at all related. Your Worship, in addition to the submissions made by my and friend Karibala here, it's our strong position that that would be a parochial interpretation of Section 5 of the Human Rights Enforcement Act. It would be a very narrow interpretation. Emphasis, Your Worship, should be put on the spirit of that provision, where Parliament, in their wisdom, said in subsection 2 of Section 5, the application may be made in any language, orally, in writing, or in any other form. Meaning that actually person can even walk into your chambers, even without any pending matter. Any person whose rights have been violated can simply walk into your chambers if by any chance they find you there and say, Your Worship, my rights have been violated. Orally there, in a language they understand. That's how informal the proceedings relating to enforcement of rights are. So we needed not even have this matter pending before you. Even if there was none, we would still walk into your chambers under that particular provision, orally. That is one leg of the submission, that we did not even to relate the matter to the proceedings before you. But on the flip side, Your Worship, even if we are by any stretch of imagination to go by their argument that you needed to correlate the proceedings before you and these matters, still, Your Worship, he misdirected himself on this. Your Worship, let's go back to the genesis of today's proceedings. On Tuesday, we objected to this honorable court issuing a production warrant against Dr. KIZZA Besigye and said, you granted him bail. They applied for a production warrant and said, this honorable court cannot issue a production warrant to a person who is on bail. And that's what gave rise to the proceedings of today. Because why would somebody admitted to bail, who is supposed to come from their home, be subjected to a production warrant? So they are here to explain why a production warrant should issue against the prison's authorities to bring back somebody who is on bail. That is the nexus. And two, Your Worship, this honorable court has got an obligation to interrogate issues relating to the freedoms and rights of a person they granted bail. There are conditions that were attached to bail, that he should comply to the orders and appears and when directed by court. But now he cannot, unless brought by the prison's authorities. He cannot of his own comply to the conditions of bail of this honorable court. If you directed that he should come back on Monday, can he bring himself? Because those are the conditions of bail. Are they going to be varied? That now he will now be brought by prison's authorities, not himself coming. How about the sureties now? The sureties who stood who were bonded by this honorable court to ensure that as and when this honorable court wants him, they should cause his appearance. Do they have now capacity to go and break the prison and bring him? So that means the orders given by this honorable court are rendered nugatory. The orders relating to bail, they are rendered nugatory. And this honorable court cannot sit and watch its orders being violated with impunity. They become illusory. That you admit somebody to bail, and then under mysterious circumstances is restrained, and the court does not interrogate that matter. So this court has that jurisdiction, actually the mandate to interrogate into those issues. So that is the nexus we can draw between the two matters. But our strongest point is that we don't even need to go there. The mere fact that one has appeared before court and raised a litany of violation of rights is enough. In our opinion, right now, Luzira has been turned into a safe house in as far as the liberties of Dr. Besigye are concerned. That is the lodging, and that notion has always been there, Your Worship. The people they call lodgers within prisons premises. He is a lodger in Luzira, which is now just being considered as a safe house for him without any pending charges. Finally, the issue of 14 days of the enforcement. I don't know where my land friend is picking it up from. That the Supreme Court said that they are given 14 days within which to keep all these suspects in custody. He's reading too much into the judgment of the Supreme Court. I invite my land friend to read it, if he hadn't. We beg to submit, Your Worship.
the submissions of both the defense and prosecution have been heard, the court takes cognizance of the fact that human rights violations, once brought to the attention of the court, must be dealt with expeditiously. However, several provisions of the law, authorities, and scenarios have been placed before the court by both the defense and prosecution. In reply, as well as rejoinder, the court owes it to itself a duty to carefully internalize and draw the provisions of the law and violations cited into perspective before a decision on the prayers can be made by both defense and prosecution to be arrived to. The matter is going to be given an adjournment for a ruling on a date. Council, I have the 28th of February, if it's available to you.
Why not Monday, Your Worship? Today is 14.
Can you work with the 20th of February? Next week is the 20th. It's within next week, 20th of February. Thursday, the 20th of February, if it's available to you.
Anything next week is available to us.
This one is next week, I think. 20th February is next week, Thursday. Just to allow me time to also internalize all the submissions you've bombarded me with. The prosecution has made submissions. I also avail myself a chance to look at the authorities and the provisions of the law. Then we can reconvene for a decision.
Tuesday, Your Worship. We do pray for your emergency for Tuesday.
And so there might be no point in me giving you a date when the court will not be able to entertain a sitting. But Thursday is very open and Friday the 21st. All within next week. Is it available to you?
If anything given to us for this matter, Your Worship, the soonest we have it disposed of, because we are talking about rights, Your Worship.
So the matter will be adjourned to Thursday, the 20th of February, for ruling. Accused is on bail in this particular matter, and his bail shall extend until then. However, the court is not blind to what is happening and that is being produced by prison authorities. So by this adjournment, I'm also ordering prison. If on such a date is still in your custody, produce him in court.
We hope they will not treat this as a remand order, Your Worship.
I do not think they need a remand warrant. They are here with the gentleman. Will you need that? And they've had the date, the 20th of February.
Because he's on bail. But they may misconstrue.
Prisons never disobeys orders of court, especially when they are present. It has never happened, at least not in all my years of service. So I don't imagine that they will not produce him unless doctor himself opts not to appear.
No, our word was for them to misconstrue this as an order of remand.
No. I have clearly stated in this particular matter, Dr. KIZZA Besigye is on bail. His bail is extended till that date. However, I am not blind that he's incarcerated somewhere in a different matter. So I'm ordering the people who are here that in the event nothing has changed and is still with them, they produce him on that date. It is as simple as that at 10 a.m. With that said, Council, I have other matters ongoing. Members of the 4th Estate, if you could vacate my court so we can proceed with other hearings.
She's ours. We shall maintain. Live, let her be there. We shall maintain. Yeah. That's it. She'll be fine. All this come for our case. We are going. Yeah, there is another case.
Yes, Counsel, what can you say following after seeing your clients, the way you use the forms and sort of, what can you say? And why have you decided to put that application in this court?
Well, first of all, the situation is really devastating to us. You can see what is happening to Dr. Besigye. You know him. He's a very strong man. But you could tell from his appearance today, although he's not well. Any keen observer, you know how Dr. Besigye strong he is. You know him very well. To be in that kind of state, it's a matter which is really worrying to us. And it's what compelled us to invoke the provisions under the Human Rights Enforcement Act, which was enacted to address situations like this. The framers of the Constitution provided that latitude to people who are faced with egregious abuse of rights to have quick remedies. It's the reason they made that provision very flexible. Section 5 of the Human Rights Enforcement Act of 2019, which was enacted in operationalizations of Chapter 4. Are we together? Because that particular act was meant to operate. That particular that act was made purposely to operationalize enforcement of rights under Chapter 4, the Bill of Rights. And the Parliament recognized there are situations where one may informally seek for remedies in exceptional circumstances like this. And the remedies should be made quickly and immediately. It's the reason we had to invoke that particular provision, Section 5, with the hope that it would come to our rescue, to the rescue of Dr. KIZZA Besigye. That you can make an application in a language you understand, you can make it verbally, orally there, or in any other manner that court may deem appropriate under the circumstances. So it's a very flexible provision. So that's what we relied upon and cited the litany of violations under Article 23, 24, and other provisions within Chapter 4 of the Constitution. Unfortunately, we have not been favored with a decision today. We leave the court premises with heavy hearts. Personally, my heart is heavy. It's heavy. It's a heart-rending situation to see Dr. Besigye in that state and to witness this impunity of the highest order, because you could tell from the submission of the state, whatever they were saying, they never cited even a single provision of the law. For us, we cited all the laws, but their submission was just casual like that, with reckless abandon. They were so callous in their response to this, so callous, not minding about the right to life under Article 24 of the Constitution, the right to life. So it's very, very, very devastating in the first place. Very, very devastating. This is what I'm telling you. It's devastating. And I want to emphasize, it's devastating.
What can you say the application on another court concerning these rights that
you see, the person who is admitted to bail must enjoy the rights guaranteed under the Constitution. It's the spirit of Article 23, the right to liberty, the right to freely exercise your freedoms, rather to enjoy your freedoms. No, the spirit of Article 23 is very clear. Why one should be admitted to bail is to enjoy their liberties. So now Dr. Besigye's liberty is curtailed unjustifiably and illegally. So it's the reason we brought to the attention of this honorable court that their orders they gave admitting Dr. Besigye to bail have been rendered illusory, have been rendered nugatory, useless, because right now he cannot enjoy the freedoms granted to him by the courts of law. This very court which said, please, you are free to go back home and attend to the proceedings or the trial from the comfort of your home. 2, the right to have access to your personal physician. It's also guaranteed under the Constitution. Right now, Dr. Besigye is in the hands of prisons authorities who have no capacity to take care of his life. Those doctors in Luzira cannot manage his life. And it's a right guaranteed under the Constitution. For heaven's sake, one wouldn't want to try a dead person because practically it's impossible. So it's the reason we believe, and this renders credence to the statement made by General Muhoozi Kainerugaba that Besigye will only leave Luzira in a coffin. All the melodrama now characterizing, whatever is happening, all these shenanigans being perpetrated by the state are calculated to keep Besigye under incarceration so that he leaves that place in a coffin, as stated by.
Do you want to test that the habeas corpus which was filed in the High Court is not taking place?
You see, we are exploring all available options under the law. You see, the beauty with the law, it creates different doors. Habeas corpus ad subjudiendum is one avenue one can explore when your liberties are curtailed, and that is a matter before the High Court. But there is also another room, I don't want to call it a window, another door here in the Magistrates Court under the Enforcement of Rights Act, Section 5 and Section 7, that one can also pursue. There are also other options. This is about enforcement of rights. The other one is habeas corpus. You can also ask for judicial. You can bring a multitude of applications in different courts. We have even the option of going back to the Supreme Court. We can go anywhere for enforcement of this judgment. So this is what we have chosen. Even in Parliament, by the way, is also enjoined to protect people's rights and liberties, to also protect, actually to guard against violation of the law. They are duty bound if indeed they were to live up to their mandate. You, the media people, you have also witnessed this. Even when you go there, they can't even allow any of you near the main entrance of Luzira. Even here, you cannot. We can try here and see if one can access him. It's not possible. We have told the court, even ourselves, when we go there as lawyers, we can't have that confidence required if you are to interact with your client. That exclusive environment where you can have a discussion in a camera, in a confidence, is not really there. So this is the horrible situation we are talking about. I cannot act in any way. Tulaba fenna wano tuli banyiikaavu. Dokita Yabaga tuli banyiikaavu ekigenze ewala. tuli banyiikaavu nnyo. Sooka embeera ya Dr. Besigye mumanyi. Dr. Besigye musajja omuvumu mu mbeera yonna, naye olaba atuuka okuba nga abeera nga bw'abadde mu kooti nga bwe mumulabye. Singa abadde mulala muntu atya obulwadde yalibadde ng'alina ku stretcher. Singa abadde muntu omulala atya obulwadde, naye wakati mu kwegumya asobola okubeerawo era omulaba ng'embeera ye mu mbeera eno twalisuubidde nti omulamuzi yaliragidde yalikoze ekiri mu mateeka. Annyonnyodde n'agamba yeetaaga okutunula amateeka, authorities n'ebirala. So ewiiki ennamba gy'atuwadde okukola ruling etuleeseemu evvuunya mu mutima, kubanga abaakola ssemateeka ne bateekamu chapter 4 oba Bill of Rights baali bakitegeeza nti waliwo eddembe ly'obuntu erituuka n'okusaanyaawo obulamu bwo. No, waliwo embeera ey'okulinnyirira eddembe ly'obuntu ng'etuuse ne ku point ey'okusaanyaawo obulamu bwo. Ekyo kye kyaleetesa Parliament okuteekawo Enforcement of Human Rights Act eya 2019 nega singa embeera ebeesusse ey'obulamuzi ng'ekizimba kisambye eddagala, osobola okwekubira enduulu mu Magistrates Court. By the way, bw'otaputa section eyo 5 osobola n'okusanga magistrate wano wabweru ng'ali mu parking n'omugamba owaayo nfa bantwala, nagamba nti ate kiki etteeka limugamba nti muwulirize omuntu oyo. Osobola okugamba nti katufune akameeza wali onyinnyonnyola ensonga zo, egamba mu lulimi lw'otegeera, orale mu bigambo bugambo oba mu nkola endala yonna. Osobola omusanga nkugambye ne mu parking wano, osobola omusanga mu chambers ze n'omugamba omulamuzi nti munnange bantwala nfa obulamu buggwawo. Omulamuzi alina obuvunaanyizibwa okuwuliriza n'akuwa remedy. Kitwenyamiza nti tuddayo tuvudde tugenda kutambula okuva wano nga tetulina ketulina mu ngalo, tetufunyeeyo remedy n'emu ku kyobulamu bwe okuba nti talina dokita we bisigadde nga we biri. Ekyokuba nga akyali mu mikono gy'abasibira mu bbwa nga tewali remand warrant, tewali court order yonna emuzisibirayo, kisigadde nga bwe kiri. Ekyokuba nti abarelatives be nabo tebasobola kumulaba, kisigadde nga bwe kiri. Ekyokuba nti ffe nga balooya be naffe bwe tugenda wali okwogera naye mubeera n'abaprisons nga bawulira bye mu planninga, bisigadde nga we biri. So tewali kikyuseewo. Kitwenyamiza nnyo okugamba nti tulinda wiiki nnamba. Katusabe Omukama atuyambe nti mu wiiki eyo wabenga dokita obulamu bwe tebwongedde kuba bubi, kubanga bwe bityo we bibeera mu bantu baffe abazze bafiira mu makomera, nti embeera ejja etabuka ne badda mu jangu nkwekule, ne badda mu kamese tambula, ono obulamu ne bwongera okusereba nga bwe gwali ku mugenzi Ssegirinya, then bagenda omuta nga embeera egaye nga takyayinza kuddangulu. So katusabe dokita aleme kugenda mu mbeera nzibu mu bulamu bwe. Kitunyize okuba tetufunye ruling olwaleero, kitunyize njagala bategeeza, simanyi na bwe nyinza kunnyonnyola butya bwe kitunyize okuba nti tuvuddeyo empty handed. Tetulina kye tuvuddeyo n'akamu bwe kati ketuzaayo nti dokita at least afunyewo akalembereza bwe kati. So impunity eno egenda maaso erina okukwata ku buli omu, kubanga kikulaze nti chapter 4 manyi kibagamba ekigambo Yerusale ekintu ekiri ekiwowongole nti chapter semateeka bamusokolamu ekinyusi kati kifuuse kiwowongole nti semateeka alina okututaasa mu chapter 4 Bill of Rights teyinza kutaasa Dr. Besigye olwaleero. Human Rights Enforcement Act eyateekebwawo Parliament okulaba nti omuntu yenna anyigiriziddwa nga atuuse ku kisenge nga bwe bakoze Dr. Besigye teyinza kutuyamba. So kino kyongedde okukakasa nti ekigendererwa kya mwami Yoweri Museveni ne banne kwe kulaba Dr. Besigye ng'akka mu ntaana kubanga General Muhoozi yagamba nti Dr. Besigye tagenda kuva mu kkomera okujjako ng'ali mu coffin. Ekyo yakyogera kubanga Dr. Besigye ali ku beyiro. Kati kooti eno eyamuwa beyiro yamugamba nti genda obeere n'eddembe lyo ojje ng'owooza kuva bweru. Kaakati kitegeeza nti ne beyiro ya wano nayo tekyagasa. Right to beyiro tekyagasa kubanga eno kooti yamuwa beyiro yamugamba genda weeyimirirwe. Naye kati kooti naye etuuse eyamuwa beyiro ng'agenda kaakati era omulamuzi omulidde agambye nti tumanyi ayina gye bamutadde eyo naye ndowooza bweru w'amateeka naye naffe tetulina kyakkola. In fact omulamuzi alinga kyagambye mu mbeera eno naffe mutusaasire. Kati omulamuzi ne bamuggyako Dr. Besigye gwe yawa beyiro ne bamumugya mu ngalo ne bamuzzaayo mu busibe obuli ebweru w'amateeka. Kikulaga eggwanga we lityuse mu kye bayita impunity mu bwamawale mu bw'okumenya amateeka. Kikulaga we tutuuse nti otuuka mu maaso g'omulamuzi eyagaba beyiro nga naye ekyokukolera takirina. So bwe buwambe bwe tulimu yembeera eyo ey'obusibira mu bbwa ey'abatamanya ŋŋamba okubanga bakola buli kye baagala okulaba ng'obulamu bwa Dokita busaanawo. Kyekigendererwa katusabe nti Mukama atukwatireko akuuma obulamu bwa Dr. Besigye kubanga ewiiki ennamba nnene ku muntu omulwadde, ewiiki nnamba nnene ku muntu atafuna bujjanjabi, ewiiki nnamba nnene ku muntu atafiidinga bulungi atalya bulungi, ewiiki nnamba nnene nnyo mu mbeera Dr. Besigye gy'alimu. Katusabe Mukama atuyamba atukwatireko.